Welcome to the Corruption Files by Crime in Court with Heather. We're peeling back the layers of lies, cover ups, and abuse of power in the justice system. Buckle up as we expose the truth. Let's begin. Hi, everyone. Welcome back to Crime in Court with Heather. This is part of my rebranding, refocusing, like reorganizing my channel. Basically, I have organized my channel into three parts now. So I'm going to do the corruption files, which is this, and every week I'm going to do a different topic, whatever seems to be um, timely or just of interest at the time. And then also, and we're going to go into different things. So we might go into some like government conspiracies. We might go into, more angles of corruption and things like that. And then my other show that I have is Trial Transcripts Exposed, where I have both, we're reading through both the Menendez brothers' second trial in 1996 that took place and the 2024 Delphi case, the homicide case of Libby German and Abby Williams. We are reading through those in the Trial Transcripts Exposed segment of my show. And then I also have Innocence Lost, which is, I brought that back. It used to be on my show where weekly I would do a little segment on someone who was wrongfully convicted and kind of walk through the steps of how people can be wrongfully convicted because it's really important, I think, that we recognize that that is a thing and it happens. False confessions happen all the time. People get wrongfully convicted all the time. And it needs to be, I think, we need to shine a light on that. So that is going to be the fourth week of every month, and every other week you're going to get a corruption files. So today, I believe, is the first episode of the corruption files. And if you've followed my channel in the past, I have covered extensively the Karen Reed trial and Turtleboy cases. During my hiatus, I stopped, but I was watching peripherally and following a lot of. There's been a lot of drama. We're not going to get to all the drama today, but I might do a drama stream just to kind of go over who's fighting and beefing with who. But for now, we're just going to stick to the most recent information in the Turtleboy case. So we are going to, today's topic is, as you can see, Cosgrove's recusal. So Cosgrove is the specially appointed prosecutor in Turtleboy's case. He's not the first prosecutor appointed in this case. We'll get into all of those details and more. So I put together this nice presentation for you, and we're going to go over all of the conflicts and everything. So I hope you enjoy. We're going to be going through, so it's not just like I'll present things on screen, but then I also have screenshots of specific filings that we reference or that I'm trying to explain. So you'll see that it's kind of a mix between presentation style and reading court docs. All right. So for anybody who doesn't know or is new to the Turtle Boy case, what's a Turtle Boy? Well, I thought that too when I first heard his name. So, who is Aidan Turtleboy Kearney? Aidan that is his name that he came up with. So he is a controversial Massachusetts investigative journalist, very well known for the Karen Reed case. He's an activist, a YouTuber, an entertainer, a satirist. He's a jokester. Like he is all, and he can also be very serious. He's all these things and more. Um, his moniker, Turtle Boy, comes from, as you can see, this is a local Worcester, as they pronounce it, Worcester attraction of a bronze statue of a boy who is, in fact, riding a turtle. So that's where turtle riders come from. A lot of his followers are named turtle riders. So, anyways, that's where he gets his moniker. And he adopted this pseudonym because 20s, he started blogging anonymously. So he started a blog back in 2013. He started writing about local corruption, uh local topics in his area, exposing people and corrupt officials. So all sorts of topics that he did locally, and it was kind of controversial. So he is also a former high school English teacher. So in the meantime, while he was teaching, he was blogging anonymously until um, he got outed, which we'll get into in just a second. He did teach for the Worcester, so he was born and raised in Worcester, and he also went on to teach for a decade in the high school system of Worcester as a high school English teacher. So he started blogging anonymously in 2013 via Turtleboy Daily News, which back then it was Turtleboy Sports. He later changed it after he was outed. He changed it to Daily News because he was not just talking about sports and things. He kind of started off with sports, but also like outing people too. Corruption. He found that that was his knack, so he changed his brand, if you will. After his identity was outed by a local newspaper, if you can imagine that, a local newspaper outed him after about 2 years of him blogging. The school board did not like that he was blogging about these controversial people and issues, so he was given an ultimatum and he took a bet on himself, and I think he did pretty well. I think he won on that bet. He bet on himself to continue his blogging and his investigative journalism and to resign as a teacher, and he went on to obviously cover the Karen Reed case, which has given him a tremendous amount of notoriety and awareness of who he is. As you may or may not know, if you're new to this, you probably don't know the ins and outs, but he was arrested basically for asking questions of the quote unquote witnesses in the Karen Reed trial. Those same witnesses that actually acted all suspicious and lied to FBI agents and things like that. Um, he asked them questions which, any normal person with a brain would want to know the answers to, but yet he was arrested for asking those questions and for instances of what most people would agree is free speech. So there's that. So we're going to go over a timeline of events. This isn't all of the events, but this is kind of a good roundabout from beginning of his charges until now. So the key events in the timeline of the Turtleboy case go as so. In October of 2023, Kearney was arrested on 8 counts of witness intimidation. I don't remember which was which, but he had charges for picketing, charges for just harassing, things that he would say on his show, though. And they would say that those were words of harassment when, again, free speech, and he's a jokester, satirist, activist, all the other things besides just a journalist. But anyways, so we move on. So that was some of those counts. And then December 2023, they expanded his charges to 16 counts, and he was originally facing like 110 years in prison. Now it's like 95 because some of them have been dropped, but it's still a tremendous amount of time that someone could be facing for asking questions. In December of 20, or December, sorry, December 26, 2023 is when his bail was revoked because he was being accused of assault and battery by Lindsay Gattani. He was charged with assault and battery, and at some point he was also charged with witness intimidation and wiretapping of Lindsay Gattani because Lindsay was a witness, so he was then therefore harassing her or something. And then also um, the wiretapping was when he was at her house. She was claiming she was going to get rid of her fake baby that she didn't have, and freaking out on him, and he was recording her, and he definitely did ask her, or not ask her, but he had the phone out and showed her, I am recording you, and she continued. So that was her willingly allowing to be recorded. But they saw it as wiretapping because the recording that they received was not the same recording, and it was shortened, and it had the part of him saying I'm recording you cut out. And we think that was probably Kate Peter who did that. So 26th of on his birthday, right after Christmas, he is thrown into jail, I should say, jail, for 60 days, again, for asking questions of the witnesses. And then on February 23rd, he was released on bail with the gag order on the impounded filings. So at some point, I don't know when the gag order came about, but he is restricted from talking about certain discovery that he's received in this case, which other people have and have been releasing and talking about, but he's been restricted. He's the only one restricted from using this information. But anyways, it's funny how the justice system is such a punishment for someone who didn't do anything wrong, other than ask questions. So he was released, and he can't talk about certain things like Lindsay Gattani, private information, stuff from the Proctor and Jen McCabe discovery from the Karen Reed case, some of it that he has that Karen Reed didn't even have. So, but he can't talk about it. All right, so moving on. In July of 2024, that same year after he was released from jail, specially appointed prosecutor Robert Cosgrove was assigned to the case. At this point, he is taking over for Ken Mello, who all of a sudden just got too sick to prosecute this case right about that same time when it all came out that um, he was colluding with Lindsay Gattani and Brian Tully to get Aidan Kearney put away, to have his bail revoked. So that all came out, and suddenly Ken Mello just is too sick to prosecute this case. Isn't that odd? It's funny how that works that way. All right, so Mello's too sick. He's out. Cosgrove's in. Let's skip ahead to May 25. We get Judge Doolin, who since then they had bunch of like hearing statuses or status hearings and like things like that where they nothing really gets accomplished. They just kind of move the needle slightly along until the next meeting when nothing else gets accomplished. So that's kind of what's been happening and pushing this to be a much longer road for poor Aiden. So Judge Doolin, as you know, there have been like, or maybe you don't know, there were many judges like back and forth in this case, and not one single one assigned to it. And he just happened to have his first motion to dismiss, heard by Judge Doolin, which was fantastic because Judge Doolin was really the only one that seemed to abide by the law and common sense. So he actually dismissed 6 counts. Some of those referred to the ones with Michael Proctor and Buchanan because they're law enforcement, and that's ridiculous that law enforcement would feel threatened. They've got the guns, but whatever. And then uh which other one was it? It might have been the wiretapping one. I don't know. He oh no, it was the conspiracy to commit a crime or whatever with looking up the license plate to find out that Jen McCabe's car was at Proctor's house. This was like before the first trial. Um, he had a charge for that too, and that was dismissed. So he's no longer on the hook for that or whatever. But he does still have 10 remaining charges left for the McAlberts and Lindsay Gattani here. So September 2025, Lindsay Gattani, out of the blue, kind of big surprise in the community, Lindsay Gattani decides she's going to sue Robert Cosgrove, Brian Tully, Michael Morrissey, and well, she's said that she's going to sue Michael Morrissey. She didn't actually do it yet, but she said it in a letter that she plans to. And then also this was just a thought on my end. Why not Ken Mello? Because he was the one colluding with her, was he not? He was the one texting her that night. Why was Ken Mello not included in her lawsuit? I really wonder this. I would like to know so much. Is it because maybe because he kind of took a back burner to the case, so she was like, we'll sue Cosgrove instead? I don't know. It doesn't make sense because Mello and Tully, weren't they the ones that gave away her information? It wasn't Cosgrove. He in the very beginning, um, Brian Tully handed over the full Lindsay Gattani phone extraction, which wasn't redacted. There were things in there that obviously, his side didn't need. It wasn't relevant for his case, but yet they gave him the whole extraction. And um, wouldn't that be on Mello, not Cosgrove? That's just a thought that I had. Anybody else? Like, what do you think? And let me know in the chat. Why not Mello? Why did they, or why did Lindsay, as we know, it's Lindsay Gattani and Grant Smith Ellis who wrote the lawsuit, I can imagine, for Cosgrove and Tully. But why not Mello? This bothers me, not Mello. I would absolutely have sued him too. Anyways, let's move on. So that same month, Cosgrove recuses himself immediately from the 2024 Gattani case. So that is the witness intimidation and wiretapping charges. As a result, because Cosgrove recuses himself, they can't find anyone else to prosecute the case. This case gets dropped. The Lindsay Gattani witness intimidation wiretapping case gets dropped by the state. Next, same month, the defense files a second motion to dismiss due to misrepresented information and undisclosed evidence. You can thank Kate Peters' involvement for this. If you recall, there was a whole hullabaloo about the names of the videos that were submitted to Cosgrove to play to the grand jury. Well, the names of those videos were in fact titled by Kate Peter with things like "gonna mess up Colin, gonna rough you up" or whatever it is. Those aren't the exact ones, don't quote me, but "gonna mess up Colin's life" or something like that. But that's not what his title of the video actually was. So obviously, they were trying to tilt the scales um, in their favor. And Kate Peter had a lot to do with that. And then all those links to those videos went missing. Also, Kate Peter most likely had something to do with that. And even maybe Cosgrove, not sure, because he's claiming, oh, I never looked at them. But Brian Tully's also like, I never click on outside links. I went to find it on a outside source. Who believes that? I don't. Anyways, moving on. October 2025, the defense files a motion to disqualify Cosgrove due to conflict of interest, which includes the Lindsay Gattani case. So Cosgrove recused himself from the Lindsay Gattani charges because Lindsay's a witness, but yet, and Lindsay's a witness in Aidan's charges too, a critical witness at that. But Cosgrove says she's not that important. We're not going to call her. What? They're trying to and he wants to stay on the case. He wants to remain on these charges. He has been fighting it, which I don't understand because he immediately recused himself after the Lindsay case. But we'll get into more of that. So on October 27th, Robert Cosgrove misses his deadline to respond to the defense's motion to dismiss or to disqualify him. So he had the deadline of October 27th. The first deadline was October 27th for his response. He missed it. Okay. Out of nowhere, we have no idea why, but suddenly Superior Court Judge Christopher Belazos is assigned. Who assigned him and why? I mean, I'm glad that he has a steady judge going forward so that it's not flip-flopping back and forth and you have to catch up the judge with the last thing every single time. I think they did that on purpose to make it confusing. But now they have an assigned judge. This is a Superior Court judge, and he seems to be pretty even keel so far. We've only seen a little bit of him. We're going to see a lot more of him very shortly. He is he so far seems to be fair, although he did go to high school with the McAlberts. He knew who they didn't. It doesn't say he knew them, but he said he did grow up in the vicinity around the McAlberts, but no connection. He says that was like the first thing he got it off. He started their first session stating that he has no connection to anybody in the case. So hopefully, he's being honest on that. Okay, so Robert Cosgrove was given the deadline of November 17th for his second deadline to respond to the motion to disqualify him. And guess what? He missed that too. He was 8 days late. So whoops, I went the wrong way. He was 8 days late filing his response to the defense, and that hurt them because in December 5th, they had a hearing, and that gave them less time to be able to prepare for that. But Cosgrove, I don't think cared because he wasn't ready to argue his motion to disqualify anyways. It makes no sense. So December comes along, and this sur-reply that we're going to read a bunch of excerpts from today, the sur-reply to Cosgrove's response was filed by the defense, and basically it argues bias and non-disclosure and a huge conflict of interest with Lindsay Gattani, which he absolutely cannot ignore or deny. So I think if Cosgrove really tries to fight this in the next hearing, I don't know. I don't think it's going to go that great for him. So the hearings to argue the motions to recuse and dismiss um, were scheduled originally, like I said, December 5th. That turned basically into a status hearing because Cosgrove was not ready to argue the motion to disqualify him. Imagine that. January 23rd comes along now, and that was the new date for this hearing to argue these motions, but that had to be continued by the defense at the very last minute due to scheduling conflicts. And the new date is tomorrow, 9:30 a.m. at Suffolk County Superior Court in front of Judge Belazos. So this is very timely. I thought to get this out, we're going to refresh our memories about the Turtleboy case and this filing before his attorneys go up and argue. So the conflict of the Commonwealth. DA Morrissey appoints Ken Mello and Robert Cosgrove. This is a picture of Ken Mello, just for your reference. Norfolk DA, that's Michael Morrissey, initially recused itself. So, yeah, the DA needed to recuse itself because of the conflict of interest here in 2023 when Aidan's charges first came about. He first assigned appointed prosecutor Ken Mello. Then Cosgrove came along in July of 2024 to replace Ken Mello due to illness. So basically, Cosgrove, the Commonwealth, is the lead prosecutor, not just any prosecutor, the lead prosecutor on all of these cases, and he must recuse himself, is the point I'm trying to make here, because as the lead prosecutor, and pretty much the only prosecutor, although Mello is still on some of these charges, um, how can you possibly, in good faith, even argue that you don't need to be disqualified due to a conflict of interest? Like that right there shows me he's not being honest. If he's going to go up there and argue in front of the judge and say, I need to stay on this case, Your Honor, because blah, 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 and blah, anything he says after that, I don't buy it. I think he can't deny, he cannot deny the um, connection, the conflict, I should say. So Cosgrove is the lead prosecutor on, so there were 2023 charges of witness intimidation and picketing, okay, for the McAlberts and Proctor and Buchanan. Those were the 2023 ones. 2025 witness intimidation charges include the new ones where basically Aidan intimidated a window, and that was it. But Chris Albert was scared of that, and Colin Albert, so he got more charges put on him. 2024 Gattani witness intimidation and wiretapping charges were also part of Cosgrove's uh, cases that he had been in charge of. But that's now been dismissed, as we said. And he has made a public statement in court saying that he is again trying to get Karen Reed and Aidan Kearney for conspiracy to commit witness intimidation by trying to maintain her phone. Her her trial has been over for over 6 months now, or however many months now. Hasn't been 6 months, 4 months, whatever it is. I don't even remember. But her trial has been over, and they still have her phone because they are trying to say that Aiden and her conspired to intimidate witnesses, which is absolutely insane. Prosecutors are meant to be impartial, as we know, but the defense claims Cosgrove cannot be. So this is from an affidavit from Mark Butterow, attorney, one of the attorneys for Aiden. And it says Ms. Katani is the alleged victim in the 2024 case and the important witness in the 2023 case and the 2025 investigation. That would be the the conspiracy to commit witness intimidation with Karen and him. So Mr. Cosgrove and Kenneth Mello both are presently assigned as special prosecutors on the 2023 case. A motion to disqualify Mr. Mello from the 2023 case is pending before the court. That was dated September 2025. Mr. Mello already has been disqualified from the 2024 case because he is a material witness. He's a witness in the Lindsay case um, because of the whole because he was part of the collusion, part of the communications that night. Lindsay was sitting there texting Ken Mello and Brian Tully that night behind Aiden's back or in front of his face, but not, but discreetly, whatever. um, Next is Mr. Cosgrove's role as special prosecutor on the 2023 and 2024 cases has recently expanded to include the 2025 investigation of the conspiracy to commit witness intimidation, which is an attempted resurrection of Mr. Mello's. So Mr. Mello tried this in 2024 with a grand jury and attempted to indict Miss Reed and Mr. Kearney for conspiracy to commit witness intimidation. That was a failed attempt at that. It did not happen. The grand jury chose not to indict them. Next, the subject matter of the 2023 case and the 2025 investigation is virtually identical. And I put this whole portion in here because I know it gets really confusing with all the different charges and everything because he's got so many of them and different years they happened. So I wanted it explained by his own attorney to give you a feel for what was going on with this case. So the 2023 and the 2025 charges involve the same alleged acts of witness intimidation against the same alleged victims. On information and belief, the only difference between the 2023 case and the 2025 investigation is that the 2025 investigation seeks to add a conspiracy indictment against Ms. Reed and Mr. Kearney and substantive witness intimidation indictments against Ms. Reed identical to many, if not all, of the substantive indictments against Mr. Kearney in the 2023 case. Isn't that something? So not only are they trying to pin Karen Reed and Aiden together, all the witness intimidation charges that Aiden has, they're basically going to try to charge Karen with too. They just cannot take the L for this one. They just can't take the loss, can they? Um, did I read all the rest of it? Yeah. So they just can't take the loss, it seems, and they're still going to try to go for more charges on Karen, which is absolutely ridiculous in my opinion. She's been acquitted twice. All right, so the next section is Gattani goes scorched earth. So Lindsay Gattani, ex paramour, whatever you want to call her, of Aiden's, there she is. That was kind of how she got his attention, was sending a picture of that to him. The core conflict in this case, though, is the fact that Lindsay Gattani makes Robert Cosgrove a civil defendant. So he can no longer be a prosecutor if he's now a defendant. Cosgrove is appointed to Kearney's case where Lindsay Gattani is a key witness. So, any of the cases, mind you, she's a key witness because they entangled her into this mess. When Gattani filed her lawsuit in September of 2025, this created irreconcilable I can't talk. This created irreconcilable bias for Cosgrove. Basically, ethically, he can't be an impartial prosecutor for Aiden and also try to discredit his own witness who is suing him. It's just not ethical. So, as a defendant, Cosgrove has a personal interest in this, and that is made very clear in Mark Bettero's filing or to disqualify Cosgrove. All right, next, remaining on the case. If Cosgrove were to remain on the case, it compromises the appearance of an impartial process for Aiden. So, and that appearance is all that you need. That little bit of appearance, it doesn't have to actually be proven that there's a bias or anything, but that appearance means you got to go. So this is also from Bettero's affidavit from October 2nd, 2025. Ms. Gattani sued Mr. Cosgrove for intentional infliction of emotional distress, negligent infliction of emotional distress, invasion of privacy, abuse of process, violation of civil rights law, breach of statutory duty negligence per se, and contribution. D.L. Tully was sued for the same with the exception of the abuse of process claim. In essence, Ms. Gattani has accused Mr. Cosgrove and D.L. Tully of intending to cause her emotional harm and other harm by purposefully breaching a duty of care that they owed her. So basically, uh, they messed up. They didn't protect her as a witness, as a victim, or whatever you want to call her, whether she was or wasn't. They didn't protect her. And she has a lot of good points in her arguments. Ms. Gattani has accused Mr. Cosgrove and D.L. Tully. He's no longer Detective Lieutenant Tully. It has come out that as of, I believe it was November of last year, he was demoted. So he is no longer a detective lieutenant. I don't know what his title is now or what his position is now, but let's just call him Tully. So, Gattani accused Cosgrove and Tully of unreasonably and offensively invading her privacy by improperly and deliberately disclosing facts about a purported sexual assault to Mr. Kearney's defense without her consent in violation of confidentiality laws. So, she's arguing that information was disclosed to the defense that shouldn't have been. Ms. Gattani has accused Mr. Cosgrove of initiating or facilitating legal processes with ulterior motives. Ms. Gattani has accused Mr. Cosgrove and Tully of interfering with her rights by threats, intimidation, and coercion. Coercion. God, sometimes I cannot talk. I'm so sorry. Yeah, so apparently Cosgrove and Tully have been threatening her. Let's see what else there is to say about that. It is therefore incumbent. This is now in the sur-reply. The sur-reply in support of the motion to disqualify Cosgrove. So they had their reply. Cosgrove then responded, and now they had their sur-reply. So that's what this is from. It is therefore incumbent that the Commonwealth fully vet Ms. Gattani's claims regarding the credibility of Tully, Ms. McCabe, and others. Ms. McCabe gets thrown in here a little bit too. Jen McCabe, obviously. So Ms. Gattani has alleged that she was pressured to cooperate by Ms. McCabe. She has claimed that Ms. McCabe provided benefits to Kate Peter and has asserted that Ms. McCabe has voodoo dolls of Mr. Kearney and Ms. Reed in her home. Ms. McCabe has voodoo dolls, apparently, of Kearney and Karen. She was told by Catherine Peter that Ms. McCabe was worried about the disclosure of text messages between her and Carrie Roberts, which revealed that a few days after John's death, they discussed who would play them in a movie. On December 20th, 2025, Ms. Roberts publicly claimed that she and Ms. McCabe joked about Sandra Bullock coming out of retirement because they, quote unquote, needed her. Yeah, right, Carrie. Ms. Roberts also said that they determined Ms. McCabe was Angelina. Obviously, the only Angelina that I know that's famous is Jolie, and we've even had an actor in mind to play Mr. O'Keefe in a movie. It is in the Commonwealth's interest to investigate these claims because if they are true, Ms. McCabe's credibility will be undermined. This is why you cannot be representing the Commonwealth and doing it properly with someone suing you. You just can't. It's just, I don't know why he's fighting it. It makes no sense to me. And more just keeps coming out that reveals the corruption in this case. So the longer he stays on it, the worse he just looks. I don't know. That's just my opinion. So Ms. Gattani will testify that D.L. Tully, or no longer D.L. Tully, intentionally mishandled her cell phone by tampering with and or deleting its contents. So he deleted things off of her phone without her permission. Tully will deny this, obviously. Mr. Cosgrove has accepted Tully's explanation without any further investigation. Clearly, these issues are relevant to Tully's credibility, and the jury should not be ignorant to the fact that the prosecutor addressing it has a personal interest in favoring Tully over Ms. Gattani because he was sued by Ms. Gattani and Tully's the co-defendant. So, there is a personal interest, some possibly even monetary, or because he might have to pay her some kind of restitution if she wins. So he has an interest to make her look bad on the stand in order to make himself and Brian Tully look better, and he has an interest in taking Brian Tully's side and taking Brian Tully's word instead of Katani's. if that makes sense, because they're co-defendants, of course. So they cannot, he just cannot stay on the case. Was there more to that phrase? No. Okay. So Mr. Cosgrove personally benefits in the civil case by discrediting Ms. Gattani in the criminal case. So he gains in his lawsuit that he's the defendant in. He gets some kind of benefit by discrediting Ms. Gattani in Aidan's criminal case. See how that works? Which means his continued participation in this matter will lessen the public's confidence in the integrity of the prosecution. Nor should the irony of Mr. Cosgrove's comments about Ms. Gattani's credibility be lost on the court. I love his writing, so that's why I included this part. A civil defendant or prosecutor with a clear personal motive to discredit his accuser and or prevent her from testifying issued her a public jury warning. A perjury warning. God, I cannot talk. A perjury warning in a case in where he will argue that the jury that Mr. Kearney attempted to intimidate witnesses by, among other things, urging them to tell the truth. Given the Commonwealth's broad interpretation of the intent and emotional injury elements of the witness intimidation statute, who knows if Ms. Gattani, a witness against Mr. Cosgrove, will allege that public statements by a powerful prosecutor slash defendant warning her about criminal exposure if she testifies constitutes witness intimidation of her by the adverse party in her lawsuit. We're going to get more into that. We'll actually see what he said. But yes, Cosgrove did threaten Gattani. Basically, if you change your tune on the stand, you could possibly get perjury charges. The case against Kearney is a high-profile matter of public concern which raises serious issues regarding the intersection of protected speech and alleged witness intimidation. Mr. Kearney and the public are entitled to a conflict-free, unbiased proceeding in which he and the public have confidence. This case cannot credibly proceed in its current posture. Mr. Cosgrove's personal interest in discrediting Ms. Gattani conflicts with Mr. Kearney's and the Commonwealth and the public interest in fair and just legal proceedings and compels his disqualification for the exact reason Mr. Cosgrove voluntarily withdrew from the 2024 case. Basically, there's no difference from the 2025 cases and 2023 cases, yet he knew that he needed to recuse himself in the Gattani cases, but not the others. It just doesn't make sense, and it makes you wonder why he's staying on so hard. It is fundamentally unfair to permit a district attorney to prosecute a case where he has a personal interest which prevents the district attorney from serving his only permissible master, the public. And that's coming from another court case. That's law. That's precedent. It is, of course, improper for a prosecutor to participate in a case where he has a pecuniary interest, possibly money or some kind of uh, likely monetary or wealth, some kind of an interest he gains from not he gains basically from discrediting Gattani. So it is uh where were we? I'll just start from the beginning. It is of course improper for a prosecutor to participate in a case where he has a pecuniary interest or if the prosecutor's personal interest as the defendant in a civil case will be furthered by a successful criminal prosecution. In such circumstances, a conflict arises because the prosecutor, as a representative of the public, must seek justice to protect the innocent as well as to convict the guilty. So he would be doing a disservice to the public if he were doing something not on the up and up. And prosecution by a civil defendant may deny the impartial exercise of a prosecutor's discretion. So a prosecutor cannot be necessarily impartial if he's also a civil defendant. And that looked like, was it case law? Or press? Yeah, that was coming from this U.S. versus Helt. Notwithstanding His personal interest in discrediting Ms. Gattani due to her allegations of misconduct against him, Mr. Cosgrove reasons that the same conflict that led him to voluntarily withdraw from the 2024 indictment does not require his disqualification here because A, Ms. Gattani is not a necessary Commonwealth witness, and B, any testimony she might provide is not relevant. He is wrong. So basically, the Commonwealth is saying she's not that important. She's not an important witness, and don't worry about it. We're not even going to call her. It's not going to change anything. It's not relevant. Like hell, it's not. You guys colluded with her to put Aiden in jail for 60 days. So there's definitely something there, but I digress. All right, so Cosgrove's personal interest. Discrediting a witness for personal gain. Before the September 2025 lawsuit, Cosgrove was fighting to protect Ms. Gattani's personal information. He was even chastising Aidan Kearney for sharing publicly information that he felt was private information from Ms. Gattani. After being sued, though, Cosgrove changes his tune. He changes his stance completely and starts to release info, this private info that he basically condemned Kearney for releasing. He started releasing in a public filing in his reply to the motion to disqualify him. That is where he basically tore down Lindsay Gattani in as many ways as he possibly could for some reason. It was very disparaging of her. He went from protecting her to let's throw it out all on the line. I don't know why. Well, because she's suing him. He might be a little bitter about that, perhaps. Maybe that's why. Maybe that shows that you are not fit to be handling this case now because your tune has changed when it comes to Lindsay's private information. He wrote in a court filing that Gattani could be prosecuted for perjury if her testimony favors the defense. So basically, in a legal document, he threw in this veiled threat of if you don't testify the way that I want, you could go to jail. I'd say that's pretty much witness intimidation right there, don't you? And with Mark Bettero's lovely language in his kind of snarky, sassy saying like, "Well, I don't know, maybe Lizzie Catani might wonder if her witness if she's been intimidated by you based on the loose statute that they have." All right, moving on. This prosecutor is now publicly attacking his very own witness. This is a picture of Aidan and Tim Bradle, his other attorney, by the way. This was his first attorney on the case. Mark Bettero came second after he kind of came on the scene for the Karen Reed case, and we saw him on people's streams and stuff. Uh, Aidan, I guess, reached out to him. Yeah, so lastly, the last point that I wanted to make was that the prosecutor is now publicly attacking his own witness, which is just not good and shouldn't be happening. Cosgrove's memo. This is Cosgrove's memo in his opposition to disqualify. He says, should this court, after hearing, permit the proposed Gattani defense testimony to the extent that Ms. Gattani's U-turn contradicts previous statements made under oath, she may expose herself to legal peril, and the court should ensure that before she proceeds, she has appointed counsel. I would think that's a threat. Absolutely. Absolutely. I would think that that is a threat. So back to the sur-reply from the defense. Bettero says Mr. Cosgrove is prosecuting Mr. Kearney in a 2025 witness intimidation indictment in which Chris Albert and Colin Albert allege they were emotionally harmed by reviewing video of Mr. Kearney clowning around as he looked into a video camera outside of Chris Albert's pizza shop. On December 5th, Mr. Cosgrove stated his preference to withdraw from the 2025 matter, so this witness intimidation charge, if the court disqualified him from the 2023 case. Ms. Gattani is unlikely to be a witness in the 2025 case, thus, the defense has not sought to disqualify Mr. Cosgrove from that matter. This begs the question, why is Mr. Cosgrove interested in remaining on the 2023 case, but willing to abandon the 2025 case? So willing to abandon that stupid window intimidation charge. But the 2023, he wants to stay on. Why? Why are you fighting and holding on so hard? A further consequence of Mr. Cosgrove being the only prosecutor on this case is that the Commonwealth's response was drafted by a conflicted prosecutor rather than one without a personal interest in seeing Ms. Gattani discredited. Not surprisingly, the tone and substance of Mr. Cosgrove's response illustrates the conflict between him and Ms. Gattani. It was very hostile. Before Ms. Gattani accused him of intentional misconduct, Mr. Cosgrove successfully fought to prevent the public release of embarrassing and private details from her personal life by seeking broad impoundment and protective orders. His view apparently changed once Ms. Gattani sued him. In his response, Mr. Cosgrove publicly regurgitated what he previously condemned Mr. Kearney for widely disseminating about Ms. Gattani. Hypocrite. What a hypocrite. Even worse, in his response, the prosecutor being sued by Ms. Gattani muses aloud about whether she might be prosecuted for perjury if she testifies as a defense witness at trial. Mr. Cosgrove's implication that Ms. Gattani anticipated U-turn testimony may expose herself to legal peril serves as a public warning to Ms. Gattani that she should not testify at Mr. Kearney's trial. That's what I heard too. Or if you do, you better testify in our favor, basically. Left unanswered and emblematic of the conflict that compels his disqualification is whether Mr. Cosgrove is A, expressing his personal opinion about Ms. Gattani's credibility and criminal exposure in the event her testimony favors Mr. Kearney, or B, whether he speaks for the public as a representative of the Commonwealth. Yeah, who are you speaking for? Are you Mr. Cosgrove, the civil defendant, or are you Mr. Cosgrove, the representative of the Commonwealth? You can't do both. The bottom line is that any scenario in which Mr. Cosgrove argues in support of Tully's credibility and or against Ms. Gattani's credibility serves his personal interest above all else. There is simply no way around the conflict. Basically, he needs to make Tully look credible, and he needs to make Gattani look to discredit her. He needs to make her look bad on the stand. It's not the way to have due process. All right, so bias and the web of litigation. This section's a little bit long, just FYI, but it's going to go fast. Trust me. Um, just saying. So this is Cosgrove. The best picture that I could get of him in the Turtleboy uh, hearings. So the impact on key witnesses and trial fairness. Basically, everything now is impacted by Cosgrove's bias. So Ms. Gattani is not just a witness, but she's a critical witness in Turtleboy's case. Her testimony will, in fact, definitely undermine Brian Tully and Jen McCabe, and other witnesses possibly involved in separate litigation, which we will get to a whole litany of other litigation that's going on right now. Also, Cosgrove has a personal interest in favoring his co-defendant Tully, we talked about that, over his accuser Gattani. A defendant has a constitutional right to expose a witness's bias, so Turtleboy has every right to expose bias of a witness or motive to lie. The jury must be aware if the prosecutor, so the jury should be told or informed if the prosecutor has some kind of bias involved in this or a personal interest in discrediting a witness. So that's going to have to come out somehow. Um, so as in the case with evidence regarding Ms. McCabe's credibility, it is in the Commonwealth's interest to determine whether Ms. Gattani's allegations about Tully are true, but it is in Mr. Cosgrove's personal interest to simply credit Ms. McCabe and his co-defendant Tully and to discredit Ms. Gattani. Moreover, Mr. Cosgrove is incapable of acting in the Commonwealth's interest regarding Ms. Gattani's allegations because he cannot directly engage his accuser. In any event, it is hard. So he can't prepare for his case when he's being accused of a crime. So he can't prepare for she's accusing him of something. So they're now co-defendant or plaintiff co-defendant relationship supersedes that. So it's all a big web that's entangled now of who's suing who. Ms. Catani will testify that Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Tully will deny this. Mr. Cosgrove has accepted. Oh, we did that in another section. Sorry. Ba, 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 ba. In June 2025, Ms. Reed was acquitted of all charges related to the death of John O'Keefe. A month later, Ms. Reed sued several witnesses against Mr. Kearney, among others, for conspiring to violate her rights, including Tully, Buchanan, Proctor, Ms. McCabe, Mr. McCabe, and Brian Albert. Some of these witnesses/defendants have threatened to sue Ms. McCabe and Mr. Kearney, but have not done so. Ms. Reed is a defendant in the pending lawsuit filed by the estate of John O'Keefe. So Karen's suing people. The witnesses and the defendants have threatened to sue people. So it's all one big mess. If the court permits Mr. Cosgrove to remain in this case, he will be prosecuting a high-profile matter of public concern alleging that Mr. Kearney intimidated witnesses while he reported on a case against a woman who was acquitted after 2 high-profile trials under the following circumstances. Before we get to those circumstances, so basically, I love this section of Bettero's paper or filing, because he really kind of lays this out. That even if you are going even if Cosgrove stays on this case, no matter who prosecutes this case, look at the optics. Look at how this case looks. Basically, Karen's been acquitted twice now, and all these other lawsuits are going on, and everybody is suing everybody. Like, what is the goal here? Whoops, I just lost my spot. Oh, here we go. Yeah, I don't even know how I did that. So, yeah. So these 2 high-profile trials that have been being talked about. Let's see what Bettero says about that. Matthew McCabe, Brian Albert, Chris Albert, Colin Albert, Juliana Nagel, and Mr. Proctor did not testify at Ms. Reed's 2025 trial, so her second trial. They weren't witnesses. Proctor did not testify at either. Oh, I'm sorry, Elizabeth Proctor did not testify at either of Miss Reed's trials. So why are there charges for her? There shouldn't be any. And all these other people, they're not witnesses anymore. So why are we still being charged? All right. So the circumstances of this case. All right. So Mr. Cosgrove has been sued for intentional misconduct by Ms. Gattani, who previously testified for the prosecution but is now a likely defense witness. Tully has been sued by Ms. Gattani for intentional misconduct and is Mr. Cosgrove's co-defendant. Tully has been sued by Ms. Reed for violating her rights. Tully has been disciplined for his misconduct and demoted, by the way. He lost some vacation days and he got demoted. Sergeant Buchanan has been sued by Ms. Reed for violating her civil rights. Buchanan has been disciplined for his failure to supervise Mr. Proctor in the Reed case. I think he lost a couple of vacation days as well. Sergeant Buchanan documented actual bias in favor of the McCabe's and Alberts and against Mr. Kearney and Ms. Reed will be exposed to the jury. So he attaches exhibits. Buchanan basically posted multiple times on social media that you should donate to the defense, the House defendants. Um, don't they had like a, what is the word I'm thinking of? Like go send me or give send go, whatever those are. You know what I'm talking about. They had one of those, and Buchanan has basically been publicly um, vocal about supporting the McAlberts, the same people who are supposedly witnesses in the case that he helped investigate. Mr. Proctor has been sued by Ms. Reed for her civil rights, for violating her civil rights. Mr. Proctor authored text disparaging Mr. Kearney. So not just the text from for Proctor talking about Ms. Reed in to his buddies, but there's also text messages that have been disclosed to Kearney's defense about Proctor disparaging Aidan Kearney and revealing his investigative bias during the MSP investigation. Mr. Proctor's repulsive text messages about Ms. Reed contributed to his termination. Mr. Proctor's electronic communications have jeopardized numerous other cases and made him a national poster child for police misconduct. I love his writing. 3 key civilian witnesses against Mr. Kearney, the McCabe's, and Brian Albert have been sued by Ms. Reed for conspiring to violate her civil rights. So, again, it's the big web of everybody suing everybody. Ms. Gattani's testimony will undermine the credibility of Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove and then likely result in Mr. Cosgrove in attacking the credibility of his civil accuser. Likely, very likely. So that was just a little roundabout of like people being punished, people being sued, people, there's a lot of things going around right now. And probably Cosgrove doesn't need to be involved in any of it. So Mr. Proctor's electronic communications have jeopardized Newman. Oh, sorry, I read that already. Next, a defendant has a constitutional right to attack a witness's credibility by establishing that witness's bias and motive to falsely accuse him. So that would go for Tully, that would go for Cosgrove, even if because Cosgrove has potentially, well, I don't know, if he wants to make himself a witness by not wanting to get rid of the case so badly. He's holding on to it. I don't know. It just makes me wonder. This includes revealing possible biases, prejudices, or ulterior motives of the witness as they may relate directly to issues or personalities in the case at hand. Assuming, for argument's sake, that Mr. Cosgrove does not call Ms. Cattani as a witness and that her testimony would not be relevant to the substance of the indicted charges. So let's assume you do not call her. Ms. Gattani's testimony will undermine the credibility of key prosecution witnesses Tully, Ms. McCabe, and possibly others. In addition to being examined about issues that adversely impact Ms. McCabe's credibility and Tully's possible tampering with her cell phone, Ms. Gattani may be questioned about separate civilian allegations pending against Tully in 2 lawsuits. In any scenario in which Mr. Cosgrove examines these witnesses and or comments on their credibility, fundamental fairness requires that the jury be made aware that the prosecutor addressing it has a personal interest in discrediting Ms. Gattani and crediting those whose credibility is damaged by Ms. Gattani. But such a scenario would expose the jury to Mr. Cosgrove's conflict of interest, which means that the proper remedy is to ensure that another disinterested prosecutor conduct these examinations and address the credibility of witnesses. So they're asking, give us another disinterested prosecutor, perhaps. It is axiomatic, or it is basically like well known, well accepted, that an individual prosecutor cannot prosecute a case in which his personal interests differ from those of the Commonwealth. Where there is a significant risk, his interests differ from the Commonwealth because he's got personal interests now because this affects him personally. He's not just a disinterested party. Where there is a significant risk that an individual prosecutor's representation of the Commonwealth in a specific matter will be materially limited by the lawyer's personal interest, the prosecutor shall not represent the Commonwealth in the case. So, recuse Cosgrove. He shall not. That is according to, it's like the first rule of conflict of interest in the Massachusetts Rules of Professional Conduct, which we will read right now. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another. So Brian Tully and Lindsay Catani's testimony will be directly adverse to one another, and Johnny McCabe as well. Or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. So he would likely, his examination of Tully would likely be disingenuous or limited because he believes that he's going to side with Tully, and he also has a personal interest, Cosgrove does, as the lawyer. So it affects him doubly. It affects how he's going to examine clients, and it affects his personal emotions in this case and how he just proceeds in anything. You're going to ask, was that done because of bias? The court must disqualify. Conclusion and requested remedy. So the defense argues overall the appearance of impropriety by not just Cosgrove or Mello, but the Norfolk County District Attorney's Office altogether. Any appearance of impartiality has been destroyed, and basically, this is Michael Morrissey. His photo. Um, I just thought it was funny. Michael Morrissey, the DA, should be completely removed from this. I don't know, did Morrissey have any ties to Cosgrove or to Mello? How did they get chosen? That's another thing that we don't know. Usually in other uh, other counties, you will give it to another county so that the other district attorney from that other county can look at it, and he doesn't have ties to that county. So that's how it's usually done. But in this case, Michael Morrissey is appointing both Ken Mello and Robert Cosgrove. So how genuine can they be if they're coming from Michael Morrissey? The prosecution will become indeed stateless. This is a great term that Mark Butterow has come up with. There will be no one to represent the state. If Cosgrove is removed, if Judge Belizos is like, yeah, you've got me convinced, defense, I'm gonna remove him from the case, or maybe he'll withdraw on his own tomorrow. I doubt it, but maybe. I don't know why they would bring it this far just to withdraw at the last minute, but you know what? I wouldn't be surprised because they do like to drag it out. So yeah, I don't know. There's so much in this filing or these filings that prove Aidan not only didn't do these things, but he was set up, and very much there's a bias going on in the investigation against him. So yes, if Cosgrove leaves, it will then become stateless, and then the state has to find someone else to take it on. or it gets dropped because no one can prosecute it. Hoping for number two, B, door number two. Let's get these charges, all of them, dropped because it's a stateless case. This is the CW's problem, not Turtleboy's. So the prosecutor or the Commonwealth has basically made it seem like, well, we can't get off this case because then there's no one else to take the case on, because they couldn't find someone for the Lindsay Catani charges, and they're not going to find someone for these charges either. So, stateless. And that is the Commonwealth's problem to resolve it, not Turtleboy's. Turtleboy, if they can't resolve it, if the state cannot resolve it, then he wins. He gets his charges dropped. The court should disqualify Cosgrove to preserve public confidence in the justice system. So, if you want anyone to ever think that if to ever have a sliver of hope again that Massachusetts could one day have hope to not be a corrupt state, you got to drop the charges. You have to, or disqualify what's his face, which would in effect basically drop the charges. All right. So in the sur-reply, as credited by the D.C. Circuit Court of Appeals, Ms. Gattani's unvetted allegations make it untenable for Mr. Cosgrove to prosecute this case because his personal interest in discrediting Ms. Gattani is in conflict with the Commonwealth's interest in seeing that justice is done, and leads to the inescapable conclusion that his participation fails to preserve the appearance of impartiality in the proceedings. As previously noted, this appearance of impartiality will be further destroyed by the Norfolk's failure, by the Norfolk's somebody, the special appointed prosecutor, whatever that stands for, failure to recuse itself. So basically, if Cosgrove fails to recuse itself, if the Norfolk County DA and Cosgrove all fail to recuse themselves from this, then Mr. Proctor's bias and disparaging comments about Mr. Kearney during the investigation and evidence of Sergeant Buchanan's lack impartiality, fundraising efforts, and advocacy on behalf of witnesses against Mr. Kearney. Again, Sergeant Buchanan was advocating for fundraising for the House defendants. Sergeant Buchanan's fundraising on behalf of prosecution witnesses obligates the Commonwealth under Brady Giglio and Rule 14 to investigate and then disclose any evidence that tends to show that the McCabe's and Alberts were offered, sought, expected, or received any possible benefits related to Sergeant Buchanan's solicitation on their behalf. This includes communications between and among Sergeant Buchanan and the witnesses, and records of money received by the witnesses related to Sergeant Buchanan's request for donations. So, because of those public social media posts that he put out there trying to advocate for the House defendants and say that, that's on the good side of justice, then he's absolutely showing his bias, and it must warrant some kind of investigation into it. But I'm sure the Commonwealth has not done so. In these circumstances, it is improper for a prosecutor to participate in a case where a threat to his personal and professional reputation is created by a bona fide civil lawsuit alleging bad faith in the performance of his official duties. Yeah, it's a lawsuit about how he handled his duties. So you might want to sit this one out, Cosgrove. This is the exact situation that exists here in light of Ms. Gattani's allegations against Mr. Cosgrove. Mr. Cosgrove's opinion that Ms. Gattani's lawsuit will not survive a motion to dismiss doesn't absolve the conflict. The conflict is created by Ms. Gattani's allegations, which, even if not the subject of an active lawsuit, create the risk of reputational and professional damage to Mr. Cosgrove. So the allegations themselves, just the fact that they're out there, are causing personal, reputational, professional damage to Cosgrove. It doesn't matter if there's merit to them. It doesn't matter if the lawsuit survives. It doesn't matter. His career is being questioned, and at this point, he needs to step out when it comes to Lindsay Gattani, for sure. Put simply, As related to Mr. Kearney, Mr. Cosgrove is the Commonwealth. As a consequence of the above described conflicts and scandals plaguing the prosecution of Mr. Kearney, the Commonwealth's last remaining prosecutor is one who already recused himself from another case due to the conflict with Ms. Gattani. The undesirable reality that Mr. Cosgrove's disqualification will leave the case stateless is the Commonwealth's problem. It may raise some difficult questions about the prosecution of Mr. Kearney, but it should not factor into Mr. Cosgrove's fitness to remain on the case. So, just because it's stateless doesn't mean Mr. Cosgrove gets to stay on the case for those reasons, or for the reason that, you don't have no one else to prosecute it. He doesn't get to stay just because no one else will do it. Accordingly, given the need to promote the appearance of justice, a trial court on a timely motion should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. The district attorney must be held to the highest ethical standards, which include even the appearance of a conflict of interest. So even if there's just an appearance, there is definitely a conflict here. Just on an appearance, he needs to be recused. Disqualification is appropriate where prosecutor has a significant personal interest in a civil matter which may impair his obligation in a criminal case. It is law. That these are coming from other sources. So these are citations. So up next, we have the hearing tomorrow, January 30th, 9:30 a.m. Eastern at the Suffolk County Superior Court. The presiding judge is Christopher Melizos, the new attorney, the new judge. So this, I think, is maybe his second or third. I think we've had a couple hearings. One might have been a Zoom, and just to like get their first status. I can't remember. And then there's definitely the December 5th one, which was supposed to be arguments for the motion to disqualify, but then Cosgrove wasn't ready. As you can see on the screen, we've got Mark Betterow, who drafted most of that document, I think, and then we also have Tim Bradle, who also does a lot of the hard work behind the scenes to keep Turtleboy out of jail. So that is that. So thank you guys so much for watching. If you liked this, please give this video a like, comment, subscribe, share, however you want to get this information out. I really would appreciate it. I'm trying to bring my channel back and be a little more focused and organized with my videos. So hopefully you guys liked this. I enjoyed putting it together for you. And let me know if there's a topic or something that interests you. It doesn't have to be Turtleboy related. It could be something else, or it could be Turtleboy related, whatever. Let me know in the comments below, and I will certainly give it my all to try to give you guys what you want. So thanks again for watching. Take care. I will see you guys in the next one. Bye. That's all for now of the Corruption Files. Thanks for digging deep with me. Like, subscribe, and comment your theories below. See you next time.